The term regulation by delay, what I'm talking about is unelected staff having the ability to keep mature cases alive without ever bringing them to main enforcement, leadership, or the commission for determination about whether this is where they should be spending their time. What a massive impact it is. You can't get D&O insurance. You can't hire executives. There are a lot of places where it's a non-public investigation. You still have to disclose it. You can't start this company to your investors.
Right.
Transaction partners, you can't do M&A. There's a lot of things you can't do. So some companies are very capital hungry. You can kill companies just through delay.
The Investor Choice Advocates Network presents SEC Roundup.
Hello, everybody, and welcome back to SEC Roundup. I'm Nick Morgan, the president and co-founder of Investor Choice Advocates Network, ICANN, and I am co-host of SEC Roundup, joined, as always, by my other co-host and co-founder, Tom Zaccaro. Hello, Tom.
Hey, Nick. How you doing?
I'm doing well. I'm doing particularly well because of our guest we have on today, Kimble Cannon. Kimble, welcome.
Thank you. Thanks for having me.
Glad to have you. And you head up the securities practice at the firm of Madavi, Bacon, Halfhill, and Young. You're also outside general counsel to a company called Nomi. So you've got a lot going on, and I don't know how you find time to do this, but the reason we wanted to have you on is because of a recent article, actually a couple of articles that you wrote, and it's relating to an issue that's very important for anyone who's potentially facing the SEC's enforcement division, and that is the Wells process. And we're sort of in this period of time when there's a lot of reform going on at the SEC in a lot of different ways, including to the enforcement division and their practices. And so your article is particularly timely. I think the article, the version I saw was called Regulation by Delay, which I thought was clever and appropriate. So before we get to the points you made in your article, Tom, for those who might not be as steeped in SEC enforcement lingo as the three of us are, can you tell us what is a Wells notice? What's the Wells process? And why is it important?
Oh,
Hey, you say.
No, go ahead,
Mike.
Kimble.
Sorry.
It's all right. That's Tom. That was a question to Tom. Okay. Yeah.
Okay, so I'm going to have to start with a little bit of a history lesson. So the Wells process has been around for over 50 years. It came about in 1972 when the then chair of the commission put together a committee to evaluate the SEC's entire enforcement program. It was chaired by John Wells, the former name partner of Rogers and Wells, which doesn't exist any longer. But for those of us who are a little bit older, we remember the Rogers and Wells as a well-established firm in New York. In any event, the committee recommended that before any enforcement recommendation is submitted to the commission, the defendant or the target should be permitted to put in a brief or a white paper arguing why the commission should not proceed with the enforcement action. Because John Wells was the chair of the committee, it became known as a Wells notice. And it has been around, and that right has been exercised, as I said, for over 50 years. When Nick and I were at the commission back in the 2000s, basically defendants were just told, we're going to charge you, and you get an opportunity to submit either a written or a video Wells notice. I think, Nick, the entire time we were there, we got one video Wells notice, Wells response, which was about 30 seconds long.
Right. On VHS.
So over time, the Wells process has been evaluated. And, probably in the late 2000s, early 2010s, the SEC promulgated their enforcement manual, and they said, let's start giving defense counsel some of the evidence we've collected, including transcripts, which otherwise would not be available to the defense. So that was in the enforcement manual, but it wasn't always observed. It wasn't always observed by all offices, and it wasn't always all the testimony. So you were still subject to some extent to the whims of the staff attorneys on the investigation. I would say in my experience over time, it became more formalized. Getting transcripts and evidence became more routine. And then with the current commission, Atkins formalized that even further and said, like, you got to give the transcripts and other evidence to the opposing counsel. And it had always been the case that the staff would give you an unreasonable period of time to do a well submission. It would be, they would conduct an investigation for 5 years and then give you 2 weeks to do a well submission. And then you say, well, that's not enough time. And it's okay. Well, we'll give you another 2 weeks. And that's it. If you want more time after that, then you take the risk that we submit our recommendation to the commission and it acts without your Wells response. Atkins has made that the process of getting more time more fair and more adopted commission-wide. But the Wells process still has a lot of uncertainties in terms of the evidence you're getting, the time to respond, and the meaningfulness of the process. Yeah. And with that history lesson, I'll go forward to our guest to talk about his concerns about the Wells process.
Yeah, and Kimble, let me sharpen that up a little bit. So thank you, Tom. That's so essentially the Wells notice is something you get during the investigation, before litigation, and it's supposed to, as you just said, it's supposed to help. It's mutually beneficial. Like the defense is able to say why the commission shouldn't bring an action, and the commission can avoid embarrassing mistakes by hearing what the defense has to say before they go to file a lawsuit, which, should be beneficial. But as with most things over time, it's become problematic. What is meant to be a helpful tool, this Wells process, has become problematic in a number of ways. So Kimble, you pointed out a number of the ways, and really you're focused on after the staff gives someone a Wells notice. So after they have said, we intend to recommend that the commission bring an action, but before the commission actually does anything, that's really the period of time you're focused on, right?
Exactly. Yes.
And what do you see as the problems with that part of the process?
Well, first of all, Tom made me feel old because my first job in the law was at Rogers and Wells. So
no kidding.
I was just remembering that.
Perfect.
And I think that the current commission is doing a great job. First of all, the revisions to the enforcement manual, I think they improve the front end of the Wells process. I just think that there is another piece of the process that needs to be addressed, and that's what Congress recognized in Dodd-Frank. That's once the staff has reached a point of issuing a Wells, we should mean they've completed their investigation and made a preliminary determination to recommend enforcement to the commission. Congress recognized that there was a need to move forward at that point, and they created this 180-day, management framework because of the concern about the fairness of the investigation. My concern is in practice, even with the current reforms and despite the language in Dodd-Frank, the post-Wells phase is still open-ended. And we're seeing that in real-world cases that affect not only parties that are being investigated, but entire industries.
Maybe, I don't mean to interrupt, but maybe it would be helpful, particularly for those who haven't been through this process. You talk about an example in your article. Maybe you could, just to put a little flesh on the issue, can you talk about, on a no-names basis, of course?
Yeah, this is no names, and this is not a client of mine. I actually mainly do litigation and work in artificial intelligence. So I'm not doing a lot of, this is certainly an interest of mine. And I think an interest because I'm very interested in the commission furthering its missions of improving transparency and capital formation. And I think that this goes right to that. But the one article that I talk about, the one investigation I talk about in the articles concerns a 2022 investigation into precious metals IRA investing. The original case was brought in 2023 under former, Chairman Gensler, and people in the practice may recall there were other precious metal cases. They were brought about the same time, was not brought. The investigation, began about the same time, but it continued until December 2025, when the staff issued a Wells notice, and they brought, preliminary determination. They were going to recommend charges under 10B, 10B5, and sections of the Advisors Act. But it never, and so this is going back to early December, but the case never reached the commission. In fact, what happened was the staff had already obtained 2.5 years of tolling before the Wells notice, and after the Wells notice, they sought additional tolling. They filed a significant number of additional subpoenas, including subpoenas for personal bank records.
After the Wells notice.
Post Wells, lots of subpoenas. Post Wells, more requests for tolling. Post Wells, no indication of it being contemplated being brought to the commission or even to the director of enforcement. Still remains at a regional office. And it's now it's more than 8 months after Wells, even though counsel, who I know, have asked for status updates. There's no indication that it's going to go before the commission for a determination. And it's significant that there was tolling in this case pre-Wells, because if you look at the allegations and the statute of limitations there, plus you add 2.5 years of additional tolling, you get into whatever the next administration is. It could bypass this administration significantly, entirely. And this is an interesting case because it really, and I think I developed this a little bit in the articles, it shows how priorities can change between different administrations, different commissioners. Under Chairman Gensler, there was a very different philosophy in enforcement where they embraced more innovative jurisdictional strategies. Arguably, the SEC doesn't have jurisdiction over this case. It has jurisdiction over precious metals ETFs, clearly, but it doesn't regulate the precious metals market itself. The CFTC regulates precious metals futures and options. The IRS has a code section about IRA investing in precious metals, including gold and silver. And the FTC regulates advertising for these products. So that pretty much covers the whole gamut of activity. The SEC really is just shoehorning here because of the, which I think was a common claim under Gensler, that because they were recommending that you diversify asset classes away from just stocks into other asset classes, that's advising about stocks because it's saying you should own more than stocks. But, clearly that's going to be philosophically probably different under different administrations.
Right.
And the other interesting fact about this case is it's gold and silver, and gold was at about $1,800 an ounce at the time all that activity took place. Now it's over $4,000 an ounce. So it's really, a lot of times, like, stocks can go to zero, stocks go up and down. We do the pump and dump cases where it goes to zero. Like, often, this is not that case. People didn't lose money here. So you don't really have, maybe in some cases you might narrowly if you try to, but it'd be hard to lose money in gold over the last couple of years, right?
Right.
So there's that element too.
Yeah.
And what troubles me is, now we're drifting towards the fourth year of this particular example not being presented to the commission. And when I use the term regulation by delay, what I'm talking about is, unelected staff having the ability to keep mature cases alive without ever bringing them to, main enforcement, leadership, or the commission for determination about whether this is whether they should be spending their time.
Yeah.
And, you don't want to assign incentives for this. I remember we were in enforcement. You get very attached to your cases. You want to see them through. You don't really want to see them killed for a reason that you don't agree with. So, so there's this opportunity with the tolling and with the failure to enforce the Dodd-Frank limitation to just keep these things alive without ever, doing anything about it.
Yep.
And what happens is the regulation itself becomes the regulatory policy, the delay itself. So, it's I guess maybe an extension of regulation through enforcement. This is regulation through the delay of bringing enforcement cases, because SEC investigations, and this is something I never really appreciated as a young enforcement attorney. I would have lawyers call me up and say, hey, this case has been open for a long time. We're trying to raise capital. I remember there was an aerospace company in Connecticut that would call me every week begging because they were trying to raise money. And it was not a priority for my group.
Right.
And I didn't appreciate what they were talking about. But now, having had more maturity and been in business, been not only in law, but in, business and banking and things like that, I realized what a massive impact it is. You can't get D&O insurance. You can't hire executives. There are a lot of places that even where it's a non-public investigation, you still have to disclose it. You can't start this company to your, investors.
Right.
Transaction partners, you can't do M&A. There's a lot of things you can't do.
Yeah.
And for some companies are very capital hungry. You can kill companies just through delay. Yeah. And where it also involves a whole sector or even a whole asset class, like precious metals, right? It not only has an effect on that company, but it has an effect on what other companies view as the risk reward. Do they have to charge higher premiums to investors to, put together a fund for future defense? They decide not to go into certain sectors because there's uncertainty about what enforcement is going to do, how they're going to view it. And so I think all these things apply here, where the Wells process is not, limited, where it's really open-ended.
Yeah. So let me recap, or, using that example. So you've got a multi-year investigation. So none of this is public yet. There's no litigation that's been initiated by the commission, it's just the staff gathering facts. They got to the point, and this is pretty typical, where they give a Wells notice, they receive or don't receive the Wells response from the company, and then it drags on. I think that's your point, is it drags on. And so whether if it's a publicly traded company or an investment advisor, they might be disclosing to third parties. And this is a fine point that most third parties might not appreciate the subtlety here, but hey, third party, we received a notice from the SEC staff that they are inclined to recommend an enforcement action, but there is no enforcement action yet, but there might be one in the future. And that just creates a ton of uncertainty. So if that status, that sort of limbo, goes on for months, years, like your point is,
Uncertainty is the worst thing in business. It took years for me to understand that uncertainty is often worse than bad news, because you can plan for it and respond to bad news, but uncertainty puts you in perpetual limbo. And there's so many things you can't do. It creates stagnation, and people leave the company because they think something bad is going to, all kinds of things. There's a whole list of bad things that happen. It would be better to bring an enforcement case than had it sit in there for a long time.
Yeah, because you don't know what the enforcement case is going to look like. So you helpfully in your article, you didn't just point to the problem. You also made some suggestions, and Tom alluded to this at the top. So Congressman Dodd-Frank, this is going back more than a decade now, said once the SEC staff gives a Wells notice, they should have 180 days to do something. And I think we can all acknowledge that is largely ignored. There are various internal mechanisms to extend that period, that 180-day period, out indefinitely. We both know, and I think you alluded to it, Tom, a few months ago, the SEC updated its internal enforcement manual. So this is sort of like the operating manual that's given to all the enforcement attorneys. Hey, this is kind of how we run our show. And Chair Atkins, I think, and through the then director of enforcement, I'm sure the new director will have a similar outlook, recognizes there need to be some changes to the way the process works, and the Wells process was reformed a little bit in the enforcement manual. And now last month, the commission published a draft strategic plan and put it out for public comment, which is a much broader document, but does touch on enforcement. So the public now has an opportunity to give input on ways the SEC's processes could improve. So tell us a little bit about we've identified this problem, this enforcement by delay. What's a way that this could be reformed that would be helpful?
Well, I think that this commission is attuned to this concern. David Woodcock actually published something just last year on this, and it's picked up in Bloomberg. We can recommend people read it. It's a short piece on how Wells needs to be reformed. He's definitely aware of it. Chairman Atkins, the other commissioners I know are aware of issues. I don't think that they were focused on this particular concern, which is what happens post Wells, and how there's really nothing requiring the staff to bring it to the commission, and that there really are incentives for the staff to not bring it to the commission's attention, particularly if it's something where it might not be something that they would expect would be favorable to the commission.
Right.
So I think that there need to be limitations on how long the staff can sit on a matter and not take action.
Yeah.
Dodd-Frank seemed to have a pretty good balance. Yeah, there were definitely safety valves in that legislation, which were pretty well thought through and allowed flexibility for the staff to go to enforcement, to go to the chairman of the commission, to the full commission to get extensions. But that meant that there was communication between enforcement, including the regional offices, and leadership, so that they were aligned on on policy and not wasting American tax dollars on enforcement staff spending time on cases that we're not going to move forward. But none of those safety, valves are there now.
Right.
And staff can just sit on cases and continue to go through their process, which may not involve bringing it to the attention of leadership. And so I think that it's important to incorporate something like that in the reform.
Yeah. You mentioned in the article the sort of perverse incentives. You didn't use the word perverse, but the incentive here. So if I'm a staff attorney, I've been working on this investigation for years. There is little downside for me to keep it open. And there is some potential downside if I close it. Closing investigations without bringing an enforcement action is not the way to make your career in the enforcement division. The way you get rewarded internally is by bringing actions. So do you think there's an opportunity here to change those incentives? Like I half seriously proposed that they should create an enforcement prosecutorial discretion award, where someone is rewarded for exercising discretion to close an investigation, rather than only having the rewards be on the side of bringing an action. So somehow disincentivize just keeping something open indefinitely.
I like that. I remember when I was working for Paul Atkins years ago at the commission, writing something about incentives and trying to solve the problem at that time of how do you incentivize staff to perform when we all can't lose our jobs, right? How do you get people to be enthusiastic, and how do you create these types of awards? And I think it's a really great idea, but I also think it comes from leadership. I remember when I was in enforcement, I initially worked for Steve Cutler, who I'd also worked with at Wilmer Cutler, so I'd known him for a while. And Steve was very good about saying one thing, which is your job is not to bring and win cases. It's to find out objectively whether there has been a violation that is harming investors. And if you find that there's not, it's a good result to not bring a case, not a bad one.
Right.
It's not a waste of time to not bring a case, because you don't actually want violations. You want people to be, to be satisfying their requirements.
Yeah.
So when I did a big investigation into securities lending and major brokerages, and we didn't find a violation in a lot of cases, and that was considered to be a fine result.
Yeah. Yep. Well, maybe once again, and maybe it'll be part of the strategic plan once it gets put out. But so for those who are interested, we'll put a link to your article in the notes to the episode. And of course, the public is welcome to comment to the SEC on ways to improve the enforcement or other SEC processes as part of the strategic plan proposal. Tom, further thoughts or questions for Kimble before we let him go?
No, I just would add, this is the time for there to be change. I think we have a commission which is very willing to reevaluate some enforcement procedures that haven't worked in the past. So hopefully we'll see something with this commission, and it'll be lasting in future administrations.
Terrific. Kimble, any final thoughts before we let you go?
Thanks so much for having me on. It was really a lot of fun.
No, we appreciate you coming on. For everyone else, if you want more information about ICANN, you can go to icanlaw.org, and we'll see you on the next SEC Roundup. Thanks.